Renu Bharti is there? Okay. So, Ravi Krishan, for your feedback. So, as I was discussing over here, artificial intelligence, according to me, if we see whatever we are making the creation, so whatever we are creating the see, nowadays we are all are using the chat GPTs, the Gemini AI. Whatever we are doing over there, we're just creating a prompt, and as per the prompt, they are giving the creative answers to our questions or whatever the things we are asking. And many people now over here, you are using chat GPT for your university assignments also, college assignments and projects, then PowerPoints, etc. So how you are doing PowerPoints or college assignments? You are just putting the topic name and chapterization and abstracts. Accordingly, you are getting the results. Okay. So do you have any idea how IP will come over here, or do you have any idea that the work, whatever you are doing, like for example, your university is giving your project assignments, and you are using the chat GPTs or JBD, whatever the AI so-called AI tools are there. Do you think work which you are doing is good work? Can anyone have any answer? Am I audible to all of you? Am I audible to all of you? I think all are in. Okay. So, Miss Jagriti, you are saying if it is copy pasted, then it is not our work. Okay, that is a good answer. But whatever I'm trying to explain over here is that nowadays we are not solely dealing upon the articles that we are having in online platforms. Okay. Sometimes we are using the AI chat GPT tools or Gemini AI also. My question is that whatever if you are using AI tools, do you think the work which you are doing, which has been assigned to you by your university professor, is your own work? My question is that.
Yes, sir. It is the work.
It is your own work. So if it is your own work, then what the work AI tools, because you are using AI tools for your results, right? So how can you claim that is your own work? Anyone? Okay. So there's no Ritvika Sen. Ritvika Sen, please give your answer. If you can unmute yourself, Ritvika Sen.
Yes, sir.
Yes.
Sir, my answer to your question will be that no, that's not the work of ours. We are not doing that. The work is doing totally by AI or ChatGPT or Gemini, whatever platform we are using.
Okay.
So in research or in publication also, when they post something, it is clearly mentioned or it is clearly written that they will be screening this, and if there is any AI content, then they will totally reject that. So I don't think that this is a very good option to write our in research or any assignments.
No, no, I'm not looking for publication aspects. I'm just saying your core assignments.
No, sir, it is not a good idea. Like if we make a habit from right now to write assignments, then it will remain in our habitual like day-to-day
Ah,
daily work. So it is not good for student life.
okay. That is a good answer from Ritvika. Great to know. So my point is that you know what is AI creativity, right? AI creativity is focused on creating the new original content through online neural language platforms by analyzing the existing data sets. Nowadays, in Gemini AI also, there was a lot of trades are there. We are using some prompts and accordingly, your art of picture has been created, right? So that is all about the AI creativity. Or do you heard about pseudo AI? Anyone over here? Do you heard about anyone? Do you heard anyone about the pseudo AI? Okay. Or if you are heard about the Draft Bot Pro, right? Anyone having any idea about Draft Bot Pro? Okay. So these are the AI outputs. Okay, these are the AI tools. Your Bot Pro. Draft Bot Pro is the AI tool which is used for legal analysis, and pseudo AI, it is an AI tool used for any musical aspects for creating the music songs as per your as per your moods or as per your prompts, whatever you will mention. Okay, the Gemini where you are using the prompt for creating images like the Ghibli art also you out about it. I think everyone. So that is all the things. So my question is that who created this? Is it the student or the type who typed the prompt or the AI developer who designed the system or the AI itself? Who created this? Can anyone give me an answer? Yes, Ritvika said.
Sir, AI doesn't create on its own. Like if we human doesn't develop it, then how will it be in use, or how will it be in person to for use? It
So
does. It is
accordingly,
not a natural
so
thing.
so accordingly, the student or the user who typed the prompt,
The user. Like
who typed the
there
prompt.
are there are many developers, app developers, who created this.
See, there's two different questions. My question is that AI uses AI platforms, which is already developed by the AI developers. Okay. My question is that when you are a student, whether you will be whether you have created the prompt, whether you have created, or you as a user, you are using the prompt to create this. So which one will be applicable?
So a student creating this.
Oh, that's great. So that is all about an examples. Okay. So the my point is that whether that will enhance your originality aspects. If I look into the point,
No, sir, it will decrease that.
so it will decrease your originality aspects, right?
Yes,
Do you think that from now onwards, if I add IP over here as a focus point, how it will be interpreted?
no idea, sir, in this field.
So okay, I am explaining you. See, I think everyone has an idea about intellectual property. I guess.
Yes, sir.
Okay. So in IP, I think you all know about all the IP laws like copyright, trademark, patent. I think everyone has an idea.
Yes, sir. Yes, sir.
Okay. 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 So I think you know about the WIPO, World Intellectual Property Organizations. WIPO theory, you know. WIPO. Okay. So AI generated works are not recognized by the traditional copyright law. natural law, it is the artificial innovation and the creations which you are preparing to all, which on your own creativity, but they are not recognizing the AI creations. Okay. Therefore, it raises a question about the copyright ownership when AI advances to produce creative works independently. Okay. So then the debate will continue whether the copyright should also extend to non-human creators, with some scholars advocating for broader definition of authorship, like you are using the prompt for creating the results in the Gemini AI or Chat GPT or Mid Journey, whatever the AI tools you are using, whether that should also come under the ambit of authorship. That is the main question or the main dilemma that is there in the copyright law with respect to AI creations. And that is the main issue, that in every publications there is a clause written that they will not take AI creative AI plagiarism if it is found in your article. They will not go for the publications. Why? Because copyright is not accepting the broader aspects of non-human authorship. It is only accepting the authors authors of his own imaginary of his own creativity. Like for example, if you are creating and if you're writing an article where you are using your own creative words, that will have a much more impact rather than if you are using the AI tools for that. Okay. So that is the question of originality. Okay. Originality, I think everyone has heard about the case of DB Modak case, Eastern Book versus DB Modak case. Have you heard about it? Everyone?
No, sir.
I think it is one of the prime case of copyright law, Eastern Book versus DB Modak case. DB Modak case you have not heard. Rameshwari photocopy case. Because this is the primary facing case of copyright law. Okay, no issue. In this both this case, the concept of originality has been discussed. I think you have to read about these cases. Eastern Book Company versus DP Modak and Rameshwari photocopy case, where the concept of fair use and fair dealing has been discussed. So, what is fair use? I think you know about fair use. Anyone? Anyone is having any idea about fair use? Okay. So fair use means when you are using a particular journal or book for copying your own work for education purpose from library, that is acceptable because you are using for your own educational purpose. So that encompasses the concept of fair use doctrine. Okay, but if we are taking it to a larger audience, that will not considered as a defense under the concept of fair use doctrine that we are using in the AI creations. Because what AI you are using the AI tools for creating your articles or your assignments, and you are then sending it to your faculties or your students to a large audience. So that will not be counted as your original written article, and that will not be considered for publication. Neither it will be considered under copyright law because it is not made in an original way, neither it encompasses the fair use doctrine. So which these two clauses or these two concepts has been discussed in the case of Eastern Book Company EBC versus DP Mother, where the concept of sweet bro. What is sweet bro? Sweet bro means the sweating and creating. See, if we look into the concept of John Locke theory, it is a labor law. What was there in labor law? Labor, what labor usually do? they usually do their work by having a sweating by sweating and make some good results of their work. Okay, like if we look about the migrant laborers and all. So that comes the point of sweat and bro doctrine. What is sweat bro doctrine? Sweat bro doctrine in copyright law is discussed as by your own creativity. If you make something, if you make some artistic aspects of, you make some artistic products or artistic creations, that will encompasses copyright protection, rather than even if you are taking any third party's help like AI tools or like Gemini or whatever so-called tools were available right now. Because like for example, if Mr. X and Mr. Y, for Mr. X writes some assignments and Mr. Y also write an assignments. Okay, now Mr. X uses his own creativity skills and Mr. Y use AI tools. Now it has submitted to the subject faculty. Ma'am has the sir or ma'am, whatever, he has awarded the marks. But Mr. X now thought of publishing this article. This assignment is in a form of article. So Mr. X goes for any journal and publish the article, and it got accepted. But for Mr. Y, it doesn't got accepted. Why? Because Mr. X uses his own creativity. That is the concept of sweat bro doctrine. Means his own thinking, critical thinking, his own way of writing, his own way of interpretation he has provided. He has not used any third party tools, neither AI tools or any copied articles from the websites. That is the concept of sweet bro doctrines that we need to follow nowadays if you want to get a genuine work or genuine creations of your own. Okay, that is the concept. Now, if we take about the authorship, now coming the concept of authorship. Authorship has some rights like the ownership rights, moral rights, duration of protection, and liability for infringements. What is the ownership rights? Like Mr. X, he has published his work and he has get the rights for his own article. So that means he can uh, share his own article to someone for reading, for giving the valuable insights and everything. Even moral rights also, it is there for the academic integrity, and the publisher which publishes the article of Mr. X both have the moral rights. Duration of protection. I think copyright you is protected for 60 years. I think you everyone knows about it. Now coming the concept of infringement. Now, Mr. Y saw that Mr. X has done this work and both have got the same kind of assignments, but Mr. X his because of his own creativity it got published, but Mr. Y now think of taking some help of AI and also Mr. X article and make a new article and want to get published. Therefore, Mr. Y will be liable for infringing the article of Mr. X. Therefore, the assumption arises an author is a human with an intent and control to make his own work in a more durable and genuine manner. Rather than if you use the AI tools, that will not count it. Any everyone is getting my point? If anyone has any question, you can ask me. Okay. Now the concept of threshold questions is that how it has got some more spark with respect to recent time. In US, as per the US jurisprudence, it has been interpreted that AI is a tool, not an author. Why it has been told? Because the level of human input determines whether the AI assisted work qualify for protection or it has got a meaningful creative decision matter or not. Because human modifications or selections or arrangements or critical analysis of AI outputs can earn the copyright protection for those contributions. Rather, if you are solely depend upon the AI tools, that cannot be granted. That is why US law on US PTO law this told in the principle that human creative spark remain essential as AI is a tool, not an author. Now, if we want to know the concept of section 2D, that is a copyright act. What is author? Author means your in dramatic sense or literary works or the artistic works, whatever he or she is showing his own artistic skills, that can be considered for publications in the public domain, and therefore they are called as author. Now over here the aspect is whether AI can be considered as an author. No. Over here in US copyright law, they strictly rejected and told that person who causes they will be considered as an author, not the AI. Now, if I took into the concept of patent, now as I discuss about the copyright, because copyright assignments and all we have discussed. Now, if I look into the concept of patent, what is patent? Patent, I think you know, everyone knows that it get protection for scientific inventions. As I think Miss Ritvika, you have told about an AI developer. I am giving a question to all of you whether AI developer can be granted patent. Can anyone please give me an answer? Whether AI developer can get patent for developing the AI. Okay, no, sir. Okay, that's good. So you are saying that AI cannot get its own patent, right? So can you please give me a clarification why AI cannot get its own patent? Because you are using the AI tools, right? And AI tools is generating your answers, and in a novel in a very different way. So why AI tools cannot get patent? Can anyone please unmute and give me an answer? Anyone? Why AI tools cannot get patent? Whether AI can be a true inventor?
Hmm. Hello everyone.
Yes. Whether AI can be considered as a true inventor? Anyone can give me an answer?
हेलो सर
Yes.
एआई एक मशीन है दैट्स व्हाई एआई इज पेटेंट
So AI is parent. Okay, I got your point. So AI can be a true inventor, or the person who is creating the AI, he will get the patent protection. Who? Tell me. Okay. Yes, Ayushi Agarwal, please unmute and tell me.
Sir, sir, I think the person who is developing the AI will have the patent in his name.
Okay, right. So why? Because human contribution is a decisive factor. AI is treated as a tool, not a right holder. Okay. Because AI system cannot own or enforce the IP rights. So therefore, the right totally vested on the person who is the true inventor of the AI developer. Got it? Now the point is that I think I just told you about the concept of AI tools and authorship also patent also. Now the point of that. One second. Okay. So there will be some now coming to the concept of personality rights framework with respect to AI. I think nowadays you have heard about the case of personality rights. Have you seen that in Delhi High Court, many cases were sought about that personality rights with respect to AI, right? Because there are several frauds also takes place through AI, and that is why many artists goes for Delhi High Court with respect to his protection for artistic for their own personality rights.
Yes, sir.
Yes, right. So you heard of Bhumi Baji. Bhumi Baji. Bhumi Baji is there. Okay, fine. So with respect to that, we have some protection that how now let's begin in Indian law, the Delhi High Court, with respect to Anil Kapoor case. What has happens with respect to Amitabh Bachchan case also? You know about the case of Amitabh Bachchan where the voice has been mimicized for the KBC, and they're creating the frauds through phone calls, right? Because AI
Yes,
can
sir.
replicate the styles, voice, expressions, and therefore it causes the threat towards the personality rights, right? So therefore,
Yes,
AI cannot override the human dignity, identity, and consent. So even if AI generated content has uncertain copyright status, but personality right act as a strong legal protection, especially for the celebrities and the public figures. So therefore, it shows a clear judicial instinct that when AI blurs authorship, would fall back on the human-centric rights. Right. Also, therefore, it gives a highlighting point that the human interest is much more greater than the machine creativity. And also, Delhi High Court never treat AI as an author or a speaker or a right bearing its own entity. Okay. Now the point is that okay, acha. One more point which I'm trying to explain is that the jurisdictional approaches. So everyone has now a dilemma that whether AI can be authorship is there in any other countries. Anyone is having any idea? If I look at the US or UK, do you think that AI authorship is there in those countries? Anyone is having any idea in US or UK about the human authorship or with respect to AI? Maybe yes, sir. Okay. See, with respect to the three different countries, like if I look at the aspect of US, UK, and India, what US is saying mostly the human authorship is mandated is compulsory. AI only works, no copyright protection. But in UK, computer generated works got recognitions, but that generated works should be done by the person, not by the AI tools. Okay, and in Europe also, it gives an emphasis on human creativity, and in India also the same thing. Person who causes the work to be created. So therefore, it gives a clear picture to all of you that we are using the AI tools, but that cannot be granted for for creativity right protections. So that is why I'm discussing with all of you that we are using the AI tools in every aspects. We are using the AI, but we have to think that where we should use, where we should not use. Okay, because there's a threshold limit is there. If it did get exceeds, that will be a deeper problems for for the aspects of the work which we are doing, and it becomes the concept of ambiguous. Now anyone is having any idea of hallucination in AI? Do you know the hallucination in AI? No, sir. Okay. See, hallucination is in AI is that we are using the chat GPT tools for writing your articles. And in legal articles, sometimes we are using the case name also. But many times, chat GPT or the whatever Gemini AI, they doesn't give the proper case name or the proper citations. And students are lawyers or the interns, they just directly copied that case name without checking whether the case is really existed or not. So that is the concept of hallucinations, because sometimes we are they just saw, okay, the first name of the case is there, so which means it is totally genuine, but they have never seen the full case or the citations. So that is the point of causing the AI hallucination. Okay, so that we
Okay.
need to. Okay. Now, the concept of takeaway is that while US adopt the strict human authorship rules, UK provide the computer generated works, but India and European Union follows only the human centric approach. Now we will discuss a case of getting images versus stability AI. Okay, so I will just give a brief introduction about a particular case. That's the international case of Getty Images versus Stability AI. In this case, what happened? The decision in this case will determine whether the training data for AI algorithms constitute an appropriate transformative use or an illegal copying of the copyrighted material. While these issues are being raised before the court in US, Indian law is ill prepared and is desperately in need of legislative intervention to keep up with the technological advancements. Like we are using the training data program in various companies, but they are not fully done by the human. They are done by AI, and which is not acceptable in US. Now my question is that whether AI training is a AI training. Okay, whether AI training is a form of reproduction, or the second question is whether AI outputs is derivating the works which will get the copyright protection or an IP protection. And the third is who is liable, developer or the user. Can anyone give me the answer? Okay. So the key legal questions which I am addressing over here is that JT Images was discussing the case of copyright with respect to protection for AI algorithms. And in the US law, it is not accepted because US law totally focus about the human-centric approach. Therefore, the main problem which was arising over here is the output of the AI generated works, whether it will be considered for protection or not. Over here, the US court and UK court also has an ongoing litigation which gives a clear picture that only a human approach towards the work, if it is done with a good faith and not in any infringement manner, it will be considered, or else not. Okay. Now the point is the concept of AI transformation with respect to various case laws. As I was discussing with you, the concept of originality. So, with respect to originality, I will just highlight one case. Do you have anyone heard about RJ Arad case? RJ Arad case. Have anyone heard about it? RJ Arad case. You don't anyone heard about it? RJ Arad case. Okay. So in RGRN case also, the concept of idea express dichotomy has been discussed. What is idea express dichotomy? Over here, I'm just discussing is that copyright only protect the ideas which will get expressed with human approach, that will get protection, neither than the AI outputs, because the human creations will be protected. If the human just say the idea, just have the idea on its own, but it has not expressed fully, then the copyright law will not give any protection towards it. So the point is that the copyright law will give protection to the ideas which get expressed in a written form or in a artistic manner. Then only the copyright will be protect. And secondly, copyright will not give the protection to the outputs which has been expressed through AI content. So that is the main aspects of idea express dichotomy. And in RJ case also, the concept of ideas that should be expressed in an artistic manner or any form is considered to be get protection under the copyright law. Okay. Now the main aspects is that secondly of the concept of defects. Defects, you know, anyone is having the idea of defects? Defects, AI generated voices, defects. Okay. So now if I use an AI generated voice and causes harm towards the person, so who will be held liable? The voice of the original person, or me, which where I'm using the voice of someone else? Who will be held liable? Okay. So it shows that AI misuse is still there, and the person who is using the AI tools and mimicking the voice will be held liable as it invoke the personality rights, privacy, and dignities. Okay. So therefore,